How are you, man?
Good, see you.
I know.
I brought one.
Holly, your hair looks really.
Okay.
Okay, yeah, we'll get a couple.
You have a good hair lead.
So.
What'd you say, Holly? Yes, we do. We all grab whatever seat we want. I actually always rotate, I never sit. Huh? I know, because I'm orange.
That is other. Yeah. Yeah.
I will.
So like today, I changed my daughter's college stuff. I mean, I say it's not. But, yes.
Good, Jamie, how are you?
Good. My plan was, once I get.
Hey, Eric.
Liz, ¿qué pasa?
How are you? I'm
Good.
good.
Doing well. Hi.
These are 8. It's already-
The older I get, time just, it's ridiculous. And this week has been absurd all around.
Absurd and like crazy stuff too. Yeah, I feel the same way.
Okay, team, it's 6 o'clock. We'll go ahead and start our work session. We will ask that everyone talking to the mic because this work session is being recorded and we have people on Zoom and we want to make sure that they hear us. So that's why we're going to be talking into the mic, okay? Okay, there you go, Ms. Sanchez.
So I'm just going to give a little bit of background for what prompted the beginning of this. But then since the initial thought, it's also grown and evolved some as well. And so I want to say maybe about 6 to 8 months ago, we were in a council meeting and I'm not sure if it was at the end under council updates or comments or but at one point we were talking about homelessness and Councilor Carson said something about doing research in another city, having some ordinances as it relates to homelessness, and he was going to forward that. And then it was also a comment, something about, you know, we need to be brainstorming on if we have all the ordinances in place that we need. So it kind of started in that area, but what was kind of more percolating as we thought about putting it on the retreat was not just brainstorming as it relates to homeless, but brainstorming as it relates to perceived crime, period. You know, if you have your own concerns, if you're hearing consistent concerns from the community members, if you're seeing certain things and it's kind of like, why is this going on? What can we do? Those types of things. So it's beyond just the homeless kind of question. I did ask Eric and Joey to prepare kind of in 2 different ways. One is there is a case that was going forward, but then is no longer, that could have implications on the municipalities having more stringent penalties than the state. And so I kind of wanted Eric to make sure he was up on that and what's going on there. And what's disturbing about that is, you know, our community could tell us, we feel that this X type of behavior is really serious. We want, you know, the highest level of fine or whatever that is. And the state could be saying, we don't think it's serious and it's really low. And so if there's going to be court cases that are undermining our authority to do that, that's obviously something we need to be thinking about. The kind of the items I asked Joey to prepare for is just to think through if he's hearing some consistent concerns from officers, if they feel like their hands are tied on anything, or if there's frustrations of not being able to do things related to certain behaviors. And I think there's been some changes at the state level, especially as it relates to drugs, that can impact the type of penalties that we can do as well. And I think there's the potential for a lot of the issues we're seeing that might be frustrating for our community might be drug related. And so that's why I wanted to make sure we were kind of up on that. So other than that little bit of preparation, this really is intended to be kind of a brainstorm, kind of throw ideas out. You guys might raise issues we don't know the answers to, and we have to go back and research and do that kind of thing. But that's kind of what the intent of this was. So with that, there is no need for me to talk any longer. You can either have Eric and Joey talk on those items, or if you want to start brainstorming, it's whatever you guys want.
How about we let interim chief Spangler and our our attorney share some of their thoughts, and then we'll open it up to council, okay?
Let me start with the case that Heather was mentioning, and then I'll move into one issue that I am recently aware of coming from Detective Birch relating to our nuisance drug house ordinance. So the case that Heather's mentioning is Mobley versus the city of Rifle. What happened in that case was Rifle has an ordinance that provides for up to 6 months in jail and $1,000 fine for theft. In this case, it was shoplifting of some $30 items. And then they also have a break point where they have a higher penalty, so more jail time and a higher fine above a certain level of theft. This happened to be the lower level of theft that these people were charged with. And so under Rifle's ordinances, they could be looking at up to 6 months of jail and up to $1,000 fine. Whereas the state, in its rehashing of criminal penalties, has limited fines for thefts of under $300 to a $300 fine and no more than 10 days in jail. So when this case came to the municipal court, the defendant's attorney raised that issue and said, look, this is a violation of equal protection under the law. Because if you're charged in state court, the most you're looking at is 10 days in jail and a $300 fine. If you're charged in Rifle Muni court, you're looking at 6 months in jail potentially. They never give them that, but 6 months in jail and a $1,000 fine. And then they don't, that's not what they would have gotten, but that's the potential. So they filed a motion to dismiss the charges because they were violating the equal protection clause of the Constitution. The Rifle municipal judge denied that motion, said that Rifle as a home rule city could set its own fines because it, that's a matter of local concern. They had specific concerns around theft. And the ACLU joined up with the defendants and filed a petition for certiorari review to the Colorado Supreme Court, which the Supreme Court granted. So the way the Supreme Court works is you have to petition to have them step in to stop something that is alleged to be improper. Supreme Court granted certiorari, and then Rifle backed down, and they changed their ordinances to align with the state penalties. So that became moot and went away, much to my disappointment. So the city prosecutors have a monthly meeting, and we were all talking about this, and I was like, Rifle, come on, stand up and take one for the team. But they didn't, and so there we are. So that question is out there. I've got the ACLU's brief if anybody is interested in that when they're looking for certiorari. I don't know how the decision will come out in the Supreme Court. It's a little worrisome that they granted certiorari, meaning they're thinking about whether that's a valid issue. So all of our ordinances fall into that similar scenario. It's a little bit different because, as you know, except for those 11 or 12 or however many it is ordinances where jail is possible on a first offense, any of our ordinance violation, there is no jail possible unless you've done 4 of those same violations within a 2-year period. So if we get stuck being a test case, our factual situation's a little bit different and maybe more defensible. I wouldn't argue that we should change anything. I'm not arguing that. If I were the Rifle and I don't know what the Rifletown attorney advised. If we were faced with that situation, I would advise you guys, well, let's take it up and we'll be a test case and we'll see what happens. So I'm not suggesting that we should do that, but be aware that that issue's out there. And then with respect to our nuisance house drug ordinance, I don't know if you guys recall that. We did that, I think in 2021, maybe 2022.
I was gonna say, we do have some new council members.
Okay, so in 2021, 2022, we were faced with a situation, and we still have this situation. We have houses that are known drug houses. What do they call them, Joey? There's a trap house. A trap house is the term for that. So we know that drug dealing happens there all the time. Sometimes manufacturing happens there. And we want to be able to deal with, shut that house down. So council passed an ordinance that says if there is evidence that a house is being used for those drug purposes, we give a warning to the owner saying, hey, you got 30 days to clean this act up. And if you don't do it, we can go to court, municipal court, and seek an order to board the house up for 364 days. We did that with the house at 10 Levita. I don't know if you all recall that there was a house at 10 Levita that was being used as a drug house. We got a court order and it was boarded up. There is a house that the police were watching, Detective Birch in particular, in a similar situation. And he called me up and wanted to know what he could do prior to that 30-day period running. And the interesting situation there is our ordinance contemplated this 30-day period because we were thinking of a situation where you've got a landlord with a tenant who is the problem. And you got to give the landlord time to get the tenant out of there before boarding the house up for a year. So that was the reason, as I recall, for that 30-day period. 10 Levita, it wasn't a landlord-tenant situation. It was the owner who was the drug dealer. And that's the same situation happening in this house. So one of the things that Detective Birch shared was that Monte Vista doesn't give anybody any time. They just say, this is a drug house, we're closing it down. And so all the people who get closed down in Monte Vista come to Alamosa, where they get a 30-day window. We can talk about whether council has interest in this, but I told Detective Birch I would think about some language that would close that loophole for where the owner's the problem, because the owner doesn't need any time. The owner just has to straighten up and fly right. That doesn't take 30 days. So if council's of a mind to entertain that, I'll go ahead and work on some of that language.
Is this something that they're ticketed already for selling drugs there?
Not necessarily. They might be, or that it might be still an ongoing investigation and they've given them the notice saying straighten up and fly right. They didn't have enough evidence to tickle, to cite them for some kind, they had sufficient evidence to show it was being used for distribution, but insufficient to make a case out of
So
it.
they'd hand them the
So-
No, it goes through municipal court. So they're still, and make sure you push your button since we're doing the Zoom. But so they still need to show evidence for the judge to issue the order to board it
And
up.
you'd probably still want a notice and straighten up, provision, but it doesn't have to be 30 days. It can be 5 days. We're going to come back in 5 days. And if we've still got evidence, then we're going to court. That's what I'm thinking. But I wouldn't want to do it without involving court, because otherwise you got a due process problem. We've got an accusation with no opportunity to meet the accusation and show that it's not true. And that's a problem. That's what I got.
Okay, so mine's gonna be more kind of broad. I know Heather mentioned like frustrations we see within our department with this perception of crime. And I think a lot of our frustration is gonna echo the same sentiment as like the community on why aren't we doing more? And it's really comes down to what we can and cannot do, or what we can take somebody to jail on versus giving them a summons or a ticket essentially, and then letting them go on scene. So this kind of, again, I apologize because it is more of an overreaching topic. So let me just give a little more context on the situation. Is Alamosa, for example, is a felony only jail. or you have your mandatory arrests on restraining order violations, warrant arrests, and or domestic violence. With that being said, most of the frustration is the repeat offenders, right? They commit a crime of, let's just use shoplifting, for example, from one business. We go, give them a citation, and we essentially release them on scene for them to walk next door and do shoplifting again. So the frustration is, the perception it looks like is we are not doing our jobs, but our hands are tied because shoplifting, theft is a misdemeanor violation and the jail just won't accept them. And this goes back years. And it was, originally it was a felony only jail to address the overcrowding issue. Now, let's just stay on theft real quick. And Eric, correct me if I'm wrong, you said 4+ theft cases before they're eligible for jail? Or is it 4+ convictions? Or not just theft cases, but similar offenses, or is it convictions? Okay. So for us, okay, within a 2-year window. Now, I know at face value, it may seem like it's easy. We know our habitual shoplifters, for example. But really to go back and figure out how many convictions they had or how many plea deals they took to combine 6 cases here into one, that's what starts making it a little harder for us. Whereas the county on the other side, they know some habitual shoplifter is going to commit the same crime over and over again. What they have built in the statute is like a 6-month, one continuous criminal episode. Therefore, if I know somebody has 10 to 15 different shopliftings within the 6 months, as long as they haven't gone through the court process, we could essentially combine them all into one higher amount to make it into that felony level of $2,000 or more. Now, I know it sounds like a lot of money, and I get that. The city's side is we don't do a continuous episode. We do the 4 or more convictions within a 2-year period. Now, I can't tell you just through experience which one works better, because again, to hit that $2,000 threshold in 6 months is a lot of product for some stores, where others it may not be. So that's the theft side of it, for example. This whole decriminalization of certain crimes is just, again, it's just a bigger issue as far as it started off for the jail overcrowding. And the idea behind, the philosophy behind it was substance use for the drug side of it shouldn't be construed as a criminal violation, more of a mental health or a health condition. Therefore, the purpose was, let's decriminalize, not legalize certain drug offenses. So where possession may not be a jailable offense now, where
Joey, can I just interrupt? So I just want to, because for council history, they may be thinking when we decriminalize some of ours, you're not talking about when we decriminalized, you're talking about at the state level at this point, right?
Yes, so when I'm
Okay.
talking about drug charges, it's just the state.
Yeah, so I want to make sure there's no confusion
Yes.
there. Sorry, thank you.
So I guess that's the gist of it is possession now is just more of a misdemeanor. So as far as like the perception of or frustration of the department or community that we hear is that how come these people aren't going to jail? And it's because simply our hands are tied. We give them a citation and we release them unless it arises to like a distribution level, right? Like a drug dealing situation. Then it's easier for us to come in and enforce something. Any questions on this stuff so far? Again, I understand it is very
So we
broad.
have Counselor, excuse me, Counselor Jackie Vio.
So how, like, if you get them for possession, is it a certain amount that they have to possess? So if they have, even if they have a lot, but they're not distributing, is that still a misdemeanor?
So most, and I don't have the exact numbers because it's broken down to like weight and what kind of controlled substance it may be. The gist of it is majority, if not all, possession charges are just misdemeanors now. Distribution is, again, amount based before it becomes a felony, or to what level of felony.
But is one of the changes the state made, I don't know what the amounts were, but it went from like this amount to now they can have this amount and it's a misdemeanor.
Yes. So they did increase a lot of the amount. Again, unless you could prove that distribution where, scales, baggies, cash. Now, so this was in 2019, I believe is when it came out, or at least it was House Bill 19-1263. Then fentanyl became a problem. So that is the only one they almost recriminalized. So that amount is still, like Heather showed, is still a small amount because they saw the danger associated with fentanyl as far as actual death goes. So now fentanyl is back to small amounts could be felonies, even simple possession of fentanyl.
Okay, Counselor Hensley?
I just have a question. You were talking about the jail being a felony type only jail, but then you referred to the county doing some things. So, what you're saying then is when they combine all of that, they're making it into a felony so that they can kind of go around that.
So in theory, that's what's allowed. I haven't personally seen it. So that's why I'm saying I don't know if the
Right.
4+ conviction will hold more weight when it gets there versus the continuous episode. But it is built into the state statute of you could go up to 6 months of a continuous episode, essentially.
And then I guess my question is, who says that it's a felony only jail?
So I don't want to speak on anybody. That's just always been what it's known for as long as I could remember.
So it's not something from the state that's saying jails can only, okay.
Nope, that came again through the overcrowding issue.
And I remember when that happened, but are we still dealing with overcrowding?
So I believe that was a big pitch on why we expanded the jail. Again, I don't want to speak on
Yeah.
the sheriff or the county. But I think that was one of the big pitches, and then it came into, let's hire enough people so we can open up every aspect of it.
So
And
I
just-
don't
just to
think
be
it's a felony
clear, we have-
only jail. I mean, we've put municipal defendants in jail, so.
Right, it's,
On-
it's,
They've taken.
it's felony only for taking them in on an arrest, but after they've been convicted, put them in jail.
Convictions and warrants, yes.
So my question is, there is a perception, I think that's what you wanted to hear about, if we think there's a perception about certain type of criminal activity. And there is a perception that people often talk about when it comes to types of offenses, and they feel like we're not holding them accountable. We're letting people just steal from local merchants, break into people's cars without any accountability, are being put in jail. So what laws, what ordinances that we have in place right now that prevents us from being more tougher on those type of offenses?
Well, so we have the 4 offenses and 2-year trigger, which we've had since, trying to remember when we did that. I think it was 2018 or 2019. That can be modified. You can drop it down to 3, you can drop it down to 2, you can drop it down to, it used to be jail was a possibility on your first offense. That's when we got slapped around and beat up by the ACLU, you may recall. And I think in general, council's sense was that wasn't appropriate. Throwing someone in jail for a $30 shoplift just wasn't appropriate unless it was a problem and became an issue. So we have people who have more than 4 offenses in that 2-year window. We have people that in coming through municipal court, we know them, and you pull their name up and there's 15 different cases that they've got going, and you pick any 2-year window in there and there's 4, 5, 6, 7 of them. They're going to jail. Oftentimes, I've never seen one more than 45 days in jail, so the sentencing authority for the judge is 90 days. I
No,
haven't seen
it's not. We're a court of record, so he can sentence.
Oh, he can do a year.
364.
364, yeah. So I have not seen him, I'm trying to think if I've ever seen him do more than 45. You may
He's
have a
done
feel
a
for that.
90-day sentence.
He's done a 90. What was that for? Do you remember?
I think it was theft, but I can't remember who it was for.
So, I mean, one of the things, if the city is looking for harsher penalties would be to sit down with the judge and say, hey, we're looking for harsher penalties. What's your justification for doing the kinds of sentencing that you're doing? So it could be letting him know about that issue. And of course, it's up to him what he does. You can't direct him to do mandatory sentencing, or you shouldn't. I guess you could direct him to do mandatory sentencing. I don't think it would be a wise idea, but you could. So that's an issue. I also, as the prosecutor, have discretion about whether I'm going to ask for jail if it's a fourth time. So if someone's got three $15 shoplifts and then their fourth one is a trespass, I'm generally not going to be asking for jail on something like that. So you can tell me, hey, prosecutor, we want you to start asking for jail as soon as that 4 or 3 or wherever you set it threshold is met. And I'll likely do that. Right now, I've got that discretion, and I'll just tell you flat out, I don't think it's appropriate to throw someone in jail when it's a trespass that triggers them over and they haven't been doing massive amounts of shoplifting. So it does hit my trigger when I'm looking at like 6 of them, and now you got a 7th and it's a trespass. I'll ask for jail. Whether the judge gives it or not, I couldn't guarantee, but other than, so my typical approach has been, if there's serious shopliftings and you get 4 of them, I'm going to be asking for jail. Otherwise, I'm asking for 24 or 48 hours of useful public service when we're at right near or under that threshold.
Okay, Counselor Carson?
I have 2 questions, but I got a quick one. What do you see an effect, a more positive effect with putting somebody to do community service or jail? How do you feel just personally? You see them not like either one more?
People dislike jail
More than just community
more than
service?
community service. Yeah, in fact, as you guys know, I had a meeting with the officers who were being frustrated about what they saw as too much leniency. And one of the things that they shared was they'll get a perpetrator and, they've got him in custody and arrested, and he just laughs and says, yeah, so what? I'll go and I'll get assigned to do useful public service, and I'll say I can't afford the fee and I won't have to do it, and that'll be that. And I'll get a fine and I don't have any money to pay the fine, so go ahead, do your worst.
So do you think since we decriminalized a lot of these, it's become worse?
I don't have any way to address that. Joey would have a better.
There's
feel
no,
for that.
is the data showing that?
So again, this is our day-to-day. It appears that way, at least when we're dealing with them, because like Eric said, a lot of times these guys are just like, hey, could you hurry up so I could go to the next store? And again, I'm only speaking on theft in this situation, but it just seems like their attitude towards our enforcement, they already know what's gonna happen, so they're nonchalant about it.
And, oh, sorry.
No, I was just gonna say, so do you think that it's a better approach for us to start considering a monetary base? Because I agree with you, because I know, I know people personally in these situations that aren't learning anything. I feel like they're just, they scoff at the system and we're not teaching them anything for sure. And I just feel we gotta do something because we're doing our youth, especially the people that are young, that are just going out there shoplifting repeatedly. We're not doing them any favors by not. When I was young, I didn't commit crimes because I didn't want to go to jail, like he said. And now they don't have any fear of that because, I don't want to be harsher. But again, when they have 6 shoplifts or their biggest fear is just a slap on the wrist. Is there a way to either look at a monetary, minimum, like, for example, your store, not to single you out, but a lot of the stuff, when you go in there, they steal one of those remote control cars, they're $400 or $500. You know what I mean? That's a lot of money. He's taking a big hit. And for that to be classified the same as some lipstick at Walmart, I don't feel that's fair for sure. But I also would like, if you could, and I'm not trying to throw more work your guys' way, but I wonder what it costs to have, even a minimum of 2 officers there on each call when they're stealing at Walmart versus, we've talked about that math before, like how much it costs them to have, how much it costs you guys to have a couple cops there dealing with shoplifting. Just straight monetary wise versus how much they're losing, or even how much these people are stealing over an extended period of time. Because, I mean, definitely people are losing money and the criminal's not earning anything at all. So I think we gotta do something. You know what I mean? From a personal standpoint, just as a citizen, knowing some of these kids that are just repeatedly shoplifting, they're not learning anything and they're not afraid. They're not afraid to get any sort of penalty.
No,
Wait.
oh, sorry, go ahead.
We can discuss monetary, but what the state's done is pretty much you can't put someone in jail for not paying. And so there's not much teeth that you can do, and I think it's fairly frustrating and
But
Holly
I
and.
think what Counselor Carson's talking about is let's make some breakpoints rather
Oh,
than
But
just.
I also have
monetary,
another
okay.
suggestion Besides the monetary, what if we impose a community service on the first offense and they don't do it, and then that's jail? The non-doing of the community service and, you know, we waive the fee. Hey, okay, you can't afford the fee, we'll waive it. You gotta do the community service or else we can't put you in jail for 10 days or something for not doing that. And then that puts some fear in them because they either gotta go put in the work, which again, some of these kids don't want to even learn how to work. And I'm just, again, speaking from kids I know, they don't want to do anything, and teaching them something is better than just letting them slide every time because they're just getting worse.
You want to talk about St. Benedict's, Holly? In that context?
Yeah, so for our UPS, we do have, most people go through RMS, which is, they have to pay $80. They can't afford it, then we've implemented the alternative UPS program where they can go participate in the cleanup days at St. Benedict, and then it counts towards their UPS hours. So if they do that, then there's no fee associated with it.
And I was gonna say, I feel like there's two potential areas of frustration. One where we maybe have more control over change, which is the path we seem to be heading down of. Do we still want the 4 per whatever many years and the monetary breakdown and all of that kind of stuff? And so that's a very good discussion. The other, though, frustration seems to be, how long by the time they get picked up for shoplifting before it works its way through the system type of thing. And I feel like it's that length of time. Not that I think anyone here thinks we pick someone up and put them in jail right away for $30 is the answer, but I'm just saying there seems to be two areas causing the frustration. And I just was pointing that out. And then Joey, I think you were getting ready to say something.
Oh, so I just want to kind of reiterate the 4+ convictions before we make it jailable currently versus like the combined continuous episode with the county, and how I don't know if one is better than the other. I think part of it is what we found out when we were talking to Eric, though, is a training and education issue on our behalf, because we were citing people in a municipal court, one charge of theft, but in our report, we're talking about 6 different incidents of theft, because we were under the impression it mirrored state statute. So once we decide for that, I don't think we've rolled it out enough to say that the 4+ convictions was really working or not on our end, because we weren't, again, just lack of training and education on our behalf on that was the new standard for the city. With that, one other thing I do want people to keep in mind is by the time it gets to court, it essentially goes through the business owner on whether they even want to call the police or not. Then when the police gets there, it's our discretion whether we think it's justified to be charged or not, whether it was, you know, whatever it may be, a pregnant lady taking an apple from Walmart. Then it gets to the prosecutor, who also has the discretion to prosecute it or not. So it may be a first-time offense coming to court. I can't tell you how many times that person has been given that break. And that's an impossible data to collect anyways.
Okay, Counselor Hanson?
So I was gonna say that, I feel that obviously, yes, a lot of the theft comes from drugs, you know, as far as but at the same time, and we want them to get help, but a lot of them aren't getting that help. And us just saying, you know, sort of decriminalizing or making it easier on them isn't pushing them to get the help they need. Like, obviously, if somebody said to you, I really want the help, then you're gonna go plan B or whatever. But if they're not that way, that's maybe being a little harder, and honestly, people having to answer for when they do things. So it's one thing to say you're addicted to drugs. It's another, though, to do a crime to support your mental health issue. And so I guess my thing there is, I also, because I hear it all the time and I see it, is that idea that, sort of that there's no penalty, there's no ramifications for doing something wrong. And so if it's something that we can support, where obviously if somebody shoplifts one time and you've never seen that person, obviously using your common sense, but if it's a regular repeat offender, that idea of taking them to jail right away so that people realize there is a ramification, because I think at this point, people are like, well, I'm gonna try to steal. If I get caught, so what? But if I don't, I got something.
No, I guess let me clarify. So the sheriff, we do have a good partnership and a working relationship with the sheriff's office. Now, in an extreme situation on not just theft, but on a misdemeanor case, they have taken them in, but it's a case by case basis and it's not something we want to abuse because we want that opportunity as needed. Now, whether it was ever used on something as minor as a theft or like a criminal mischief, I can't tell you if it has or not. I don't know.
Okay, Counselor Dominguez?
You said that the data it's hard to find or put together when on multiple thefts?
No, so what I'm saying is, if a shoplifter, how many breaks they might have been given until it got to the courtroom. Once it's charged, it's easy to collect, but I don't know if this said person has been given 3 breaks from a business owner prior to us
Oh, you
finally
mean
getting called.
immunity
Yeah.
from a business?
Yes.
So,
Excuse me, or from the cop exercising his or her discretion, it's a $5 candy bar and they say, you know what? I'm not gonna charge it.
Yeah, and right, wrong, or indifferent, when I was a patrolman, I mean, there are times where I get called to a shoplifter and I don't feel okay morally or ethically charging them, so we would just cover, or I would cover the cost. And it's usually, a parfait or something because they were hungry. Not to make it okay or excusing it, but a difference in theft. So what I'm saying is by the time it does come to the courtroom, I think people lose sight of the fact that maybe this is a first time offender, but in reality, I can't tell you how many breaks this person has given up until it's come to a courtroom.
so it sounds to me like no matter what we move forward, there's gonna be extra work, right? Is there a way to keep track of these instances through the police department? Would that benefit you to keep, or is it too much work?
So I just don't think it's again, it's not a plausible solution where a business owner will call me and say, hey, I gave Jamie Dominguez a break today, just so you're aware of it, kind of thing.
No, they never gave me a break.
Yeah.
I went to jail the
Yeah.
first time I stole a pen from Lovenchuck. And I went to jail every single time I got a DUI. And I went to jail every single, and it scared the shit out of me. And I think it has some significance, jail, but where I just not sure why the jail isn't on this call, or you said you have a good relationship with them, like is the capacity even there now
To hold,
to send people to jail like we need to?
I think on a case by case basis it is, but again, I would hate to speak for the sheriff's office. But really to bring everybody in that are habitual offenders, there's no way we could house all of them.
So go ahead, Ms. Sanchez.
So part of also what we were gonna do is think through after the meeting with the police department and Eric was, is there any changes we want to recommend to you as it relates to the, 4 times and this many times and all of that kind of stuff? And so that's something we still plan to do, to sit down and think through that and see if there's a recommendation there. But I also think then the conversation from counsel with your prosecutor and judge, if you think that the recommendation should be harsher, once it does trigger, right now it's at 4. If you don't feel like the recommendations and the punishments have been harsh enough, because there's still, like, if you were getting it on the first, and I'm talking as a layperson, if you're getting it on the first time and it's something that was scaring you, that may not be to the extreme council wants to go back to, but if we're at 4 or 5 times, do you feel like it needs to be more serious than the types of things that are coming out of it? And that could be a healthy discussion.
Counselor Dominguez.
So I guess with that being said, the ones that you do know that have been there multiple times, I think from my learning and because I've had my share of trouble and I'm not scared to talk about it, it is important to draw the line somewhere or else I would have never learned. I really wouldn't have. And I think if there's not room, that conversation needs to happen too. And if there is an identified factor of substance abuse, when I was there, I wasn't there for substance abuse, I was there for getting in trouble, but other than alcohol, but they had people who were allowed to go in the jail and visit with people in the rooms, not only just probation officers and lawyers, but they would let other people come in there, like church groups, mentorships, to talk to these people. I heard somebody say it a while ago, I think it was you, just throwing them in there. Sometimes it doesn't work, but if you can reach them when they're in a place to talk about why or what, I think that needs to be entertained too, that it's a very important piece.
Yeah, and I also believe, I think when we came up with the 4 offenses within a certain time period, we were dealing with the ACLU findings and things like that. So we were trying to make sure that we were abiding by some of those regulations with good intentions. But now it looks and it appears and it feels like that's not working. Whether we have information to verify that or not, it feels like it's not working. The community feels like that's not working. So along with Councilor Carson, when he mentioned if there's something we can do to maybe, let's say if it's a first offense, give them opportunity to have community services. But if they don't follow through with that and then impose jail, make that a consequence, because I'm feeling like there are no consequences. I've come to court and I've seen our city attorney and the judge have people walk in here in a total disrespect for both of them. The way they come in here, their appearance, their mannerism, and things like that. So it's setting a tone. I was frustrated when I walked in and saw somebody wearing a hoodie. When I was you went to court, you never disrespect. You stood up when a judge walked in. You stood up and you said, yes, sir, yes, ma'am, no, sir, no, ma'am. You were very mindful and thoughtful, but it feels like they're disrespecting every aspect of what we have in this community as far as being accountable for action. So I'm for us looking and having and entertaining those conversations with making it a little bit more stricter and holding people accountable for their actions. So I saw 2 mics on. I saw Councilor Carson, I saw Councilor Cribbs, but I don't remember which one. Okay, Councilor Cribbs, then Councilor Carson.
Oh, okay. So, and I agree with you, Mayor. I think we as a council have said repeatedly, especially when it comes to policing and crime, is that the pre-COVID days, it's completely different now. But it seems like the things that we put into place at that time have stayed there. So while everything else has shifted, what we have done hasn't shifted with it. And just listening to the 2 different aspects, it sounds like I'm hearing the word discretionary a lot, and I understand that you need that to a certain extent, but I also think that maybe it's time for all the players that have discretionary around it come to the table together and figure out some parameters about what that means so that you're more of a united front. And it won't be so much of if it passes your sniff test and it moves on, then it should be good for the prosecutor to prosecute, and it should be good for, so it won't turn around on you somewhere in the stream.
So this is an interesting, some historical perspective on this. When I first started as the prosecutor, I would see, let's take shoplifting because that's the obvious one. I'd see these shoplifting charges come in literally for $3 candy bars, $5 candy bars. And so I talked to Chief Anderson and I said, are you serious that you want me to prosecute these? Because I assume that if your guys write them up, they think they should be prosecuted. And he told me, no, I'm telling them to write them up and you, Mr. Prosecutor, exercise the discretion. So we had a little bit of a disconnect on that, on those 2 separate levels of discretion, kind of like you're talking about. And we need to get our our thoughts straight on how that works. And I actually haven't talked with Joey about that at all, and we'll have a new chief at some point, whoever that may be, probably sit down and have that conversation. But so you're raising the issue of where do we draw the boundaries for officer discretion? Where do we draw the boundaries for prosecutor discretion, judge discretion, and how do those three interact?
And taking that one step further, Eric, just to recognize that if it passes the officer's discretion and it comes to you, then the judge needs to recognize that. If you take it to the judge needs to recognize that and not have the police put all this work into it because they see it, boots on the ground. You're backing them up and then have that get turned around. So I think it's all three of you coming to the table and not nitpicking the details, but having a general idea of if it comes to where you're presenting it to them, the judge should take it more seriously in the sense, instead of the 10 days, that kind of thing.
Well, and he does. I mean, the judge doesn't have discretion to throw a charge out. If I bring a charge, he finds whether he sees there's sufficient evidence to prove beyond a reasonable doubt that the crime was committed or not. His only discretion then isn't, is this worth prosecuting? It's okay. Has it been proven? And if it's been proven, then his discretion is what kind of sentence do I hand down?
And there's this fine line, and there's probably guidance either through CML or other national organizations that the three parties are kind of in check of each other as well. And so you really have to be careful of thinking we're going to sit around the table with a judge and like start dictating how because he is supposed to be objective, he's supposed to, and those types of things. Now, I think where we've talked is, can we get information to the judge about some of the dissatisfaction that's going on and that it feels like a slap on the wrist or some things like that is to get that information out. But when I've worked with other municipalities, the guidance we would give council, because they would hire and evaluate the municipal judge as well, is council can't be involved in like individual cases. But if there's this overall pattern of where you feel they're either too harsh, too lenient, those types of things, then those are very good discussions to have as well. But so I think conversations can happen, but we also have to be mindful of the different roles, and protecting their professional ethics type of thing. So
Okay, I'm gonna go in the order we have here. Counselor Carson, Counselor Dominguez, and then Counselor Hensley.
This is just kind of a historical question because I don't remember. Did we go from one extreme with the previous judge to now a completely different extreme? Like because I was in here, I saw him be a judge. I saw him do his job and he was mean. You know what I mean? He was extremely mean. I saw him make people cry and everything.
But he violated the law too, frankly.
Yeah, no, yeah, I mean, there's a way you can hand down justice and not be a jerk about it for sure. But from a conviction or like a prosecution standpoint, did we go like from one extreme completely to the other extreme and we decriminalized everything? And if that's the case, then more from a policy standpoint, I think we did a lot of damage by doing a lot of.
I think there's a difference between the type of judge you're picking, and I think there's a difference there. You could have decriminalized, had the other judge, and potentially be seeing different types of judgments handed out. Do you see what I'm saying? So there's two different things that happened at the exact same
Yeah,
time.
no, and that's. what I'm
You've
saying.
got a different judge who is different. And we decriminalized some things.
So yeah, we just completely flipped all the way then.
And I don't think it would be fair to say that this judge is an extreme judge and extremely lenient or.
No, I'm saying from a policy standpoint, for sure, because the judge, again, has to be objective. He has to do his job without anyone telling him what to do. But by us giving, through our guidance, by decriminalizing everything, I guess, by us saying, You know, we're changing all these laws now. We laid out the blueprint for him to do his job now, and by changing that, is that our best, I guess, is that our best avenue of giving him the guidance that we would need from a council and a community standpoint, is just looking at the ones that we decriminalized and maybe, or fixing issues like the, you know, the community service to jail or things like that, just helping change the policy and giving him more tools to do, you know, to do a better, to hand out some knowledge, I guess, or some lessons, to give out some lessons, because it is about coming to court is about learning a lesson. You know, you want to learn from what you did. And if you're not learning, then it's futile and it just costs money to the community and we're not really engaging in anything. And so do we change some of these policies and that be the conversation instead of, you know, so from a council standpoint, that's something we have to think about. I guess that's what I'm challenging us to do is, do we have to look at the policies immediately? Because us telling you and the judge to sit down and talk when we're not really looking at anything different from a policy standpoint, is that going to be productive? So I guess that's the question I posed.
So I don't want to speak out of turn, but so part of this work session, I was under the impression was to figure out what kind of stances the city want to take. Do we want to revisit it? When you say, do we see it go from one extreme to the next? I think that's a little harsh. It's more like we saw what happened with one, ACLU came in, then it was almost a knee-jerk reaction. Just to kind of get back to a baseline, and I think where we lost it is to keep tweaking it as we went through, as opposed to just keeping it as is since the knee-jerk reaction.
So we've learned from the future.
Yep.
Now we know we have to fix it.
Now it should
Give you
be
guys more tools, yeah.
what we're doing and just, is it still working or could we tweak it? Or should we tweak it?
And I was thinking, I made a note to myself as you will most likely have continued discussions on this in the future, especially if we're going to make changes, is just from a historical perspective, maybe sending back out the ACLU report, because again, they didn't file anything from a legal perspective, but they pretty much did a smear campaign and cherry picked different types of things that they wanted to show. Cause I was pretty defensive of our judge and how he was painted. I don't think was very fair. Type of situation, but I want to make sure, you know, we're tough now, but if, you know, if we go too far, even then back to the other way, we understand what we went through at that point in time. And so I'm not sending it to calm or cool your jets at all as far as being motivated to do something, but it's just more of, it's been a while. And I don't want us to forget why you did make some of the changes too. But I do think it was a smear campaign, so.
He was mean. He scared me. I ended up in front of him because of dog tickets. And he, first of all, I stayed in here all day. So I don't know why he put me last on the docket. But Karen had been pretty lenient with me. You know, my dog would get out all the time and she'd give me a ticket one every 7 times, you know what I mean, or something. And so I ended up in front of him and he threatened me. He's like, okay, I don't care how good of a dog owner you are, blah, blah, blah. If I see you again because of the dog, you bet you're gonna wish you had gotten one of those $2,000 kennels. So he basically told me, I'm gonna throw you in jail, you know, if you don't take care of it. So I was scared. So I left from here. I need to fix my dog problem. And during that time, I was running for office and somebody asked me about him and I made a comment about him. And then I was afraid I was gonna end up in front of him again. And he was gonna tear me up because I said he was mean, you know, but he was pretty vicious. I saw him be pretty mean. So that was one extreme. And I've been in front of this judge and he's very nice. And I think he's super fair, but I just meant, did we go from a policy standpoint from one extreme?
Thank you, Counselor Carson. Counselor Dominguez and then Counselor Hensley.
I just want to point out that if it's your first time getting caught, I think it's very important to go through the system. This might be more for business owners and other people who have the discretion to decide whether or not to charge or for you to do your job. But I think in my learning, when it gets to the prosecutor and the judge, they can dismiss if it's a first offense, right? But I think it's very important to take that whole step because you have to worry till you go to court and you have to think about it. If you're let go right at the scene just because it's $1, it might be more detrimental to that person than it is, not doing something. And I just, that's really important.
So,
Thank you. Counselor Hensley, then.
so I was gonna say exactly what you just said. So that was one thing. The other thing, just real quick, because I know we're short on time, is I think with the judge, I have no reason to not feel he wouldn't listen to our guidance. We've had different counselors, and part of it was always giving him toolboxes, because that word was used a lot. Here's more things in your toolbox. And so maybe it's really saying, okay, now that we've looked at everything, yes, you still have the toolbox, but we want you to also use. And I think, honestly, I think a lot of it's guidance from us to let him know the direction we want to go.
Yeah, and I think, like you mentioned earlier, that we came up with some of these adjustments, but we never followed up. I think we probably should have this conversation on an annual basis, at least make sure that we're adjusting to the current environment that we're in.
And then I know we were all, as a municipality, kind of watching the rifle case, but Aurora, and I'm not saying we need to mirror Aurora by any means, but they're doing something similar, and they just passed a new theft ordinance where they're again, now they're taking that stand on first offense, 3 days, second offense. It's just a tier system up until, I think, 6 months in jail.
Okay,
I do want to put on our radar too, that we did want to talk about, and I know you did some research on it, aggressive panhandling, aggressive approaching of people at the doors of the stores. You know, we've had people come in. We had the lady come in who his son had got beat up. He was a cart person. So I do want to not forget about that conversation. You know, people can get run over at these intersections. Somebody just got run over at an intersection. And so if you have somebody that's panhandling and they step out, you know, and so I don't know if we want to consider thinking about, or keep that on our radar, because I know you had looked into, was it Houston or Austin that had tightened it
Well,
up?
and I think we did research it, and so while it's not organized the same way under categories as where you found it, it's covered in other areas. So if we have individuals behaving aggressively, we do have ordinances that can address that, and they are.
And if we've got problematic intersections, so this is the way the law has kind of where it has arrived on panhandling. Aggressive panhandling, we cover under harassment. But if we have problematic intersections that pose safety issues, there have been cases that deal with that. And generally, if you can show data that support a conclusion that that's a problematic intersection, you can ban panhandling at that intersection. But if you just try to do it and say, yeah, this is an intersection on Highway 160 and it's an island in the middle, so therefore it's dangerous, you're going to get shut down. That's going to be a First Amendment violation.
But it could be education to the public to know that if they are seeing aggressive panhandling, to call us, to call police, so then we can address it.
okay. So we're gonna have to end this work session right now because meeting is gonna start in 3 minutes. So, and we have to put these tables up, okay?